Hi, very good morning. It's a Bombay High Court judgment. Aerocom Cushions Private Limited versus Assistant Commissioner Anti-Evasion. Issue before the Bombay High Court was whether transfer of leasehold rights will be subject to levy of GST, Goods and Service Tax. Facts of the case, very briefly, ACPL, that is Aerocom Cushion Private Limited, it was holding 95 years lease on a plot belonging to MIDC, Maharashtra Industrial Development Corporation. So MIDC. The rights under the lease are transferable in terms of the lease deed executed between ACPL and MIDC. ACPL assigned the leasehold rights in that plot to Rishta Industries with the consent of MIDC. According to department, this transfer of assignment of right will amount to supply of service under section 7(1). And then they try to levy tax on that transaction. Section 7(1) read with schedule 2 clause 2b, clause 2 within bracket small b. For immediate reference I am giving only that part. Schedule 2 deals with activities or transactions to be treated as supply of goods or supply of services. Clause 2b states any lease or letting out of a building including a commercial, industrial or residential complex for business or commerce, either wholly or partly, that is treated as supply of service under that clause. The transaction in this case is neither lease nor sublease but assignment of leasehold rights. So this is very important. Transaction is neither lease nor sublease but assignment of leasehold rights. In the show cause notice, it was specifically stated that the transaction is not a sublease. That they have agreed. The department agreed. The department treated it as a transaction seeking compensation to transfer the rights. According to the department, this activity amounts to service taxable under other miscellaneous services at the rate of 18%. That is the heading under which the department tried to put this service, treating transfer of leasehold rights as other miscellaneous services, and then they wanted to tax that. Bombay High Court looked into what are the other miscellaneous services mentioned there in that entry. It was washing, cleaning, beauty and physical well-being services, etc. Bombay High Court said that such petty services cannot be equated with leasehold rights of immovable property. Bombay High Court was of the opinion that the show cause notice can be quashed on that ground alone. You are treating leasehold rights, transfer of leasehold rights as cleaning or washing services. So Bombay High Court said I can quash the show cause notice on that basis alone. But still it entered into the merits of the case and said the transaction on the face of it constitutes transfer of immovable property. It pertains to transfer of benefits arising out of immovable property and has no nexus whatsoever with the business of ACPL. Bombay High Court said that the essential element of supply of service in the course of business or in furtherance of business is completely absent in this case. Bombay High Court agreed with the judgment of the Gujarat Chamber of Commerce and Industry, agreed with the judgment of Gujarat High Court in Gujarat Chamber of Commerce and Industry versus Union of India, wherein Gujarat High Court held that transfer of leasehold rights for a consideration shall be assignment, sale, or transfer of benefits arising out of immovable property, and hence it would not be subject to levy of GST. Bombay High Court further said that the decision of the Gujarat High Court is binding on the Bombay authorities, GST authorities. The court said until a contrary decision is given by any other competent High Court, it is binding on the authorities in the state of Bombay. The authorities have to proceed on the footing that the law declared by the High Court, though of another state, because in this case it was Gujarat High Court, though of another state, is the final law of the land. In that sense, the decision of the Gujarat High Court is binding on the authorities and they must have followed that Gujarat decision, Gujarat High Court decision. That is what the Bombay High Court said. Bombay High Court allowed the writ petition and quashed the show cause notice. Thank you very much. Have a great Makara Sankranti. Bye.